It's a citation that was issued back on the 26th of April, almost half past noon, 11 Mile and Bacon area of Berkeley, for operating while using a mobile electronic device. You can admit or deny responsibility, or you can admit responsibility with an explanation. How do you wish to proceed?
I'm denying it.
Okay. Please raise your right hands. Do you swear or affirm that the testimony you are about to give in this matter will be the truth?
I do.
I do, Your Honor.
The sergeant will testify first, please.
Okay.
Your Honor, on April 26th, at approximately 12:27 in the afternoon, I was westbound on 11 Mile from Bacon. I could see the vehicle driven by Ms. Galani, which was a blue Ford Escape behind me, and I could see the vehicle swing. I can also see her looking down at the same time. Her vehicle is basically going from the end of the lane to the other end of the lane marker. Slowed down to let her pass. As she approached my side, I could see that she was holding her cell phone in her hand. At that point, she made contact with me and dropped the phone down. Stopped her for the violation of using her mobile device. At that point, she had her phone in her lap.
Okay, let's pause here. The officer's testimony is critical. Not only did he claim he saw her swerving and holding the phone, but he's also got body cam footage backing it up. That's 2 strikes already. In court, when a cop testifies with physical evidence, it's like walking in with a stacked deck. The defendant may insist she wasn't distracted, but the moment she admits, even casually, that she used the phone for just a hot second, the law doesn't care if it was 1 second or 1 minute. That's enough for a violation. Question for you. If you were the judge, would you take her side, given her nervousness, or trust the officer's
when I
video?
made contact with her, explained that reason for the stop, and she said that she was just looking at her phone for a hot second to order food. Also have body cam video of the interaction with her where she admits to the use of the phone. I did issue a citation for using the mobile electronic device while driving.
Ms. Jelani?
So, I was driving normally perfectly fine. The only reason why I swerved is because I dropped something, a perfume dropped, and the cop was making me nervous. You see, I'm already in big trouble. You know, I'm not trying to stir nothing. No, like, I see a cop next to me. I'm not gonna be on my phone. I'm not gonna do something for me to get a ticket. I was scared the whole time when the cop was next to me. I was praying and hoping he wouldn't pull me over because I wasn't doing nothing. I wasn't on my phone. I was gonna order food, but I was like, you know what? I'll just put my phone away and I'll just order when I get there, because I was just gonna order fries, and usually fries don't take long. I was already scared, like I said. I don't want to pay another fine. I'm already paying fines. Like, when there's a cop next to me, I get very scared for some reason. I'm very scared of cops. And then out of nowhere, he just put his sirens on, and I was very confused on why he was pulling me over, because I was not operating my phone. When he came up to me, I was very, very nervous. So I said whatever, just for him to leave me alone. But
You got so nervous you told him something that wasn't true.
And here's the moment everything cracks. Notice how the judge keeps pressing with that yes or no question. Did you tell him the truth or not? The defendant tries to dance around it, adding excuses, emotional appeals, even bringing up her past trauma. But the problem is this. She already admitted earlier that she used the phone for just a hot second. Once that's out there, it doesn't matter what she says after. This is a classic example of how nervousness in court can backfire. Sometimes people talk themselves straight into a guilty verdict. Be honest, if you were in her shoes, would you have kept talking or just stayed silent?
True.
Because
why would you lie to him?
I wasn't.
Why would you lie to him?
No, I wasn't lying to him.
You told him the truth.
No, just wait.
Did you tell him the truth or not?
The thing is,
did you tell him the truth or not?
Yes, I was telling him the truth.
Did you tell him the truth or not? That's a yes or a no.
I was telling him the truth. I wasn't on my phone.
You told him that you were using it only for a hot second, did you not?
Yeah, I just told you right now that I was using it for just a 1 second and then I put it away. I was like, I'll just order food when I get there because I'll order fries because they usually don't take long. Because I was on my lunch break. And I mean, I'm a female. When I see a cop, I get very scared. As you can see, I'm a Muslim woman, so I get very scared when there's a cop. And I'm already very traumatized from past experience. So when I seen him, he just came up to my car and I was already crying because I didn't want to I didn't want a ticket and I wasn't doing anything wrong. When I swerved,
Still on probation? Are you still on probation?
yes, Your Honor. That's why I don't want any you know.
The way to avoid fines and the way to avoid convictions is to comply with the law. It's not to ask other people to close their eyes and ignore something.
And there it is, the gavel moment. The judge makes it crystal clear. It doesn't matter if it was a quick glance, a dropped perfume bottle, or ordering fries. The law says no phone in your hand while driving, period. What's fascinating? Here is how she thought admitting to a little use might earn her leniency, but instead it sealed the deal. That $200 fine might feel steep, especially since she claims she's already broke. But think about the alternative. A distracted driver could cause an accident that costs lives. This case really highlights how strict distracted driving laws are enforced today.
The fine on this matter, you're clearly responsible. You've admitted the phone was in your hand and you had it. You were using it for a quote unquote hot second. Well, that's the violation. You are responsible. The fine is $200. It can be paid online or by mail, or it can be paid at the courthouse counter.
But I wasn't operating it. I had it in my hand. And then when I seen the cop, well, I mean, I'm broke.
Ready, Your Honor. Michael G. Mitchell on behalf of Mr. Day, who is present via Zoom, and we consent to same. Mr. Day, please state your name for the record.
John David Day.
Your Honor, at this time, I'd waive any formal reading, stand my client mute, ask that a not guilty plea be entered. Further, he would be requesting the assistance of appointed or assigned counsel.
Thank you. A plea of not guilty does enter. Next step in the process will be a pretrial conference. You'll be notified of the conference date and time, Mr. Day, by mail. Are you still on Ravina?
Yes, sir.
The phone number we have ends 9572.
Yes, Judge.
Okay. And you're requesting counsel. Esteban, Detective Berenga.
Thank you, Your Honor. Mr. Day does have a prior conviction for operating while intoxicated back in 2018. Alcohol was a factor in this incident as he was intoxicated at the time the incident unfolded. So I would ask for an appropriate bond with alcohol provisions or testing attached to it.
Thank you. Mr. Mitchell, were you able to hear Detective Berenga?
Now we shift gears into a whole new case involving Mr. Day, and here's where things get even more interesting. The detective points out alcohol was a factor, mentioning a prior OWI conviction. But notice how the defense attorney immediately jumps in to argue the charges don't officially include intoxicated driving. This back and forth is a perfect example of courtroom strategy. The prosecution wants restrictions to keep the public safe, while the defense is fighting to make sure the punishment doesn't go beyond what's on paper. It raises an important question. Should a judge consider past behavior in context when setting bond, or stick strictly to the current charges?
I did, Your Honor. My client is 34 years old. He tells me he's full-time employed at Schwartz Machine as a shipping and logistics manager. He's been employed in that capacity for the past couple of years. He was forthright with me, Your Honor. He did indicate he had a couple of, a couple of misdemeanor convictions approximately 7 years ago. My understanding, there are no other issues in the interim. I think Detective Berenga indicated that he was intoxicated. I'll note he wasn't charged with operating while impaired. I certainly have not seen a copy of the incident report. I'm not privy to all the facts and circumstances, Your Honor, but as I see it, he's not being charged with an impaired or intoxicated offense. I would just ask the court to take that into account when setting conditions of bond. I think he would be an appropriate candidate for a personal bond with reasonable conditions because he doesn't have a history of failing to appear. As I understand it, Your Honor, I'm not looking at his file. I don't know that a tether would be necessary, but that's all I have to add at this time.
Thank you. Mr. Day, while you're on this bond, you can't use alcohol.
Not a problem. I will literally wear an alcohol tether because I work at 4:30 in the morning. Well, I would go to work at 6 in the morning, so I would not be able to go to most testing facilities.
Oh.
So, if an ankle monitor or a home monitor or anything that you would like me to do in that matter, I am willing to apply with.
Okay. The two alternatives to the ETG testing would either be a tether or a sober link. I don't know what the difference in cost is. I wouldn't be surprised, but they were both in the same ballpark. I think the sober link is a handheld device into which you would blow 3 or 4 times a day. It's about the size of a large cell phone.
Okay.
And I think that, in my opinion, that is less likely to have false positive than the ankle monitor, the ankle bracelet.
Okay.
So let's go with the sober link.
So,
And it'll be 4 times a day. We'll have pretrial service supervision. You'll get the sober link through them, make the arrangements. Now you're going to need to call pretrial services tomorrow. They're going to give you, and when they release you today, a piece of paper that looks like this. Okay, it'll be a blue quarter piece. It's got the phone number for pretrial services to call right in the middle of it, but it is area code 248-451-2315. So when you see the number, you'll recognize it. Give them a call tomorrow. You can't call them today because your file's on my desk and they would know why you were calling them. So call them tomorrow, make the arrangements to get it, and it should be operational by Tuesday of next week. And Tuesday of next week would be the 29th. SoberLink be operational by the end of the business day. July 29th. Purpose of a bond is not to punish you before the trial, is to make sure you get here for the trial and to ensure the safety of the public pending. I think we've addressed the alcohol issue, and the bond itself will be $2,500 personal. Hey, you want to make sure that pretrial services gets rolling on this tomorrow because that SoberLink machine has to be operational by the end of the business day on Tuesday.
understood. Is this a device that is portable and I can charge? Because
It's not much larger than this.
Okay, awesome.
And it's a personal bond. And again, no alcohol whatsoever. Okay.
And that wraps up today's intense courtroom session. Let's break it down. In the first case, the driver who thought she could explain away a hot second on her phone walked out $200 poorer. A tough reminder that distracted driving laws leave zero wiggle room. In the second, Mr. Day avoided harsher penalties but still walked away with strict alcohol monitoring and a $2,500 personal bond. Both cases show the same truth. In Judge Fischer's courtroom, excuses won't fly, and accountability is the only way forward. What do you think? Was the judge fair in both rulings, or too strict? Drop your thoughts in the comments below. And if you found this breakdown as shocking as we did, make sure to hit that like button, share this video with a friend, and don't forget to subscribe for more jaw-dropping courtroom moments. Until next time, stay safe and keep your phones out of your hands when driving.